Hi, I am Jonathan Meyers. I am a New York and New Jersey employment attorney, and I'm here to talk to you again about how professionals can claim age discrimination without harming their reputation. This is part 2 of a 2-part video series. Now, a brief disclaimer, I am not in this video providing you with legal advice, and I'm not your attorney. If you want me to be your attorney or give you advice or represent you, then you need to contact me and enter into a written retainer agreement. All right, so let's get to it. Last time we talked about 2 of the most private methods of asserting age discrimination claims. So option 1 was getting behind-the-scenes advice from an employment attorney. Option 2 was having an attorney write a demand letter for you and negotiate on your behalf. Today we're going to talk about 2 semi-private and 1 fully public ways of pursuing an age discrimination claim. These are option 3, filing an administrative charge, option 4, filing a lawsuit, and option 5, arbitration. So now let's talk about option 3, filing an administrative charge. This option requires you to put some work into the case, but not a whole lot, and it requires the employer to put some work into the case, but not too much. It's sort of like getting to the halfway point of filing a lawsuit. Now, an individual can file a claim of discrimination with the Equal Employment Opportunity Commission, the EEOC, or with state or city, if you're in New York, city administrative agencies. My firm typically files with the EEOC. The EEOC will investigate the claims, but it is rare for anything of real substance to happen at the EEOC. The employer, like I said, they have to do a little work. They typically file a position statement, which can give us a preview of their position and give us some of their best evidence to look at, so we get a preview. More substantively, though, the EEOC offers mediation, and these are informal sessions in which the parties are encouraged to try to come to a settlement. The mediator cannot force any party to accept a settlement. It's up to the parties. So you both have to agree, but if the parties come and are motivated and both want to settle, it usually happens. On a positive note, many employers will focus on your allegations much more seriously when you're at the EEOC than when you had just maybe tried to negotiate on your own or have an attorney write a demand letter. That said, the employer and their attorneys know that the EEOC process, although it requires some work on their part, it's only some work, and that they're not going to have to pay a whole lot in attorney's fees to defend themselves. So the employer may feel some pressure to settle, but not a tremendous amount, just some. But sometimes some is enough. A positive of the EEOC, a pro, is that even though the filing is technically a public record, there's no practical way for outsiders to obtain a copy of your filings or to even know that you filed with the EEOC. Still, this option has its limitations. If the parties fail to settle at the EEOC's mediation, then it is extremely unlikely that your matter is going to come to a conclusion before that agency. Most of the time, this process ends with the EEOC referring you to the courts to file a lawsuit. And I did mention state and New York city administrative agency. It is possible to file there, and they do render decisions and can award damages there, but there are such severe limits on the monetary recovery that you can get that for most people who have a pretty good damages claim, have had good earnings, and have been out of work for a long time, they're not going to want to go there. It's just not going to make economic sense. So now let's talk about option 4. This is the big one. This is litigation, filing a lawsuit. This is the most time-consuming option. Litigation can go on for years, and you have to put a lot of work into your case. You might be thinking, well, hey, isn't that why I hire a lawyer? The lawyer's supposed to do work on the case. Well, yes, but the lawyer can only work with what you give them. And in litigation, you must give your lawyer a lot. You will spend hours and hours and hours on reviewing your files for documents and information to give to your lawyer, answering hundreds of questions, preparing for a deposition, and sitting for your deposition, which is a nerve-wracking experience. You have to sit in on other people's depositions, the other side's witnesses, third parties. You have to sign documents and statements. You have to sit through mediation sessions. You have to prepare for trial. You have to testify at trial, be at the whole trial. And if the case concludes at trial, regardless of who wins or loses, if there's a very substantial result, there's going to be an appeal, and you have to go through that process too. And all of this work spans years. Now, here's a practical thing to think about. If you get a job next week, or even 6 months from now, you will probably lose interest in your lawsuit. You will want to focus on your new job, and you will not want to be taking time off of work to go to depositions and sit in your attorney's office and that sort of thing. So it's important to factor that in. Usually, if a client comes to me early enough, we have a good amount of time to determine whether it makes sense to go all the way and file a lawsuit. If the client comes to me and within a few months gets a new job, it may make sense to accept a relatively low settlement offer at that point, maybe through the demand letter and negotiation process, and to not file a lawsuit. But if not, and if it looks like the client may never obtain comparable employment, then it just may not make financial sense to settle low and early. It may make more financial sense to litigate. If you have very little to lose and a lot to potentially gain by filing a lawsuit, then that helps to make the choice to fight much easier. As is the theme of this discussion, it's important for clients to also consider reputational issues, more so than anything else with litigation. Because ultimately, even if you are in the right, other people and other prospective employers may think less of you if you are involved in an employment lawsuit. Prospective employers may view you as litigious or a bad apple and not want to hire you for fear that you might cause them trouble. And there's just really no way of getting around the risk that this kind of perception could hurt your future career prospects. Filing a lawsuit, it is a public event, literally. Reporters can go to the courthouse or online and find out about your case and make it front page news. Now, that making it front page news doesn't happen all the time, doesn't happen all that often, but if your case is against a celebrity employer or it's part of a highly topical issue that's trending in the news at the time, it could happen. More likely, though, is the prospect that your prospective employer out in the future, when you're applying for a job, could do an internet search on you and find out about your case. And oftentimes it's difficult for them to do so, but sometimes it's not. Sometimes it's easier. For example, if you have a very unique name, or if the media has reported on your case. Also, the online visibility of your case can vary depending upon what court it's filed in. And your attorney, should be able to give you an informed assessment of the likelihood that your case might come up in, sort of high on the list in internet searches on you. Age discrimination cases, I think more so than other types of employment cases, see the plaintiff, the individual, put in a different kind of posture, a different kind of place than many other kinds of plaintiffs. And that's because, there are many bankers, managers, professionals who have commanded six-figure or higher salaries for years, and then they discover that after being fired at the age of 55 or 60, they can no longer get a job that's anywhere near what they were making or have that same kind of status. Sometimes people in these very high-paying positions end up being forced to accept employment at big box retail stores, and that's all they can get, and that's probably all they'll ever get going forward. So these individuals typically see little downside in going all the way and litigating. One of the pros of litigating is that your employer will almost certainly take your claims much more seriously than if you followed one of the prior options that we talked about. And that's because the risks, the costs, the other negative factors for the employer are much higher with a lawsuit. And that's why litigation often commands higher settlement value than some of the other options we've talked about. Litigation work is extremely time consuming, and can generate attorneys' bills in the tens of thousands of dollars per month for many months over the course of many years. And that can put pressure on the employer, but it also can also put pressure on you. Most people, including high earners, cannot afford to pay an attorney by the hour, and that's why most litigation is performed by plaintiffs' attorneys on an on a contingency basis instead of an hourly basis. But even if you are not paying by the hour and you don't have to pay anything until there's a judgment or a settlement, you still have to invest your time and your effort, and you have to sit in the hot seat for a deposition or a trial. So those are some negatives, but the other thing is that on top of all this, you are exposing yourself and your allegations publicly. Your testimony, your evidence, whether you win or lose at trial, all of that is exposed to the whole world. So you need to recognize the seriousness of these considerations and accept that when you decide to file a lawsuit. Now finally, we're going to talk about arbitration. This is optional, or it might be required. Some employers require employees to sign agreements to arbitrate claims, including age discrimination claims. Some individuals in the financial services sector will invariably have to arbitrate, or you may or may not have to arbitrate. Your lawyer will probably ask you for documents that you signed during your employment to see if you committed yourself to arbitration. Now, the advantage of arbitration over filing a lawsuit is that it is faster and, in theory, less expensive, although that less expensive part is usually a benefit the employer gets. The disadvantage is that the employer has typically much less to lose. And why is that? That's because usually costs less to defend an arbitration than a lawsuit. And it's not a public record. The employer, as much as that might be valuable to you, the converse is that there's no threat of bad publicity for the employer. And also, arbitrators are often less willing than juries to make big awards, and they're usually more exacting about the law and the facts than juries might be. So there's a consensus among attorneys, rightly or wrongly, that arbitrators don't give as big awards, and also that they're more likely than a jury or court to completely throw a plaintiff's case, toss it out. Now, while most individuals prefer to be in court, there may be reasons why you might want to opt into arbitration even if you don't have to. And first and foremost is that arbitration is not public. It's a private forum. The outside world doesn't know about it, or at least doesn't know about what goes on in it, for the most part. Next, if you have a strong case that is relatively simple and easy to prove, then you might have less concerns about giving up a jury trial right. You might prefer the speed of the process of arbitration. Litigation, particularly in New York State courts where I practice, can be maddeningly slow. So getting a resolution or arbitration faster might be more attractive. Now, if you want to arbitrate in your employer and you did not enter into an arbitration agreement during your employment, don't worry about that. Most employers would jump at the opportunity to go to arbitration instead of court. So now I'm going to end this video series by telling you something that you probably won't like and most clients don't like to hear. And that is that ultimately there is no easy answer to the overarching question we have here. You want to be able to claim age discrimination, but you don't want the blowback from it that could harm your reputation. There are options, as we've talked about, but each have their own pros and cons. However, I think with legal counsel, you can make informed judgments about which path will get you the best bang for your buck and also balance your reputational concerns against them. So thank you for watching. If you have questions about age discrimination or other employment law issues, I'd love to hear from you. The best way to reach me is by email, jmeyers@mfglegal.com. Thanks.